The Supreme Court shock that so many Americans talk about in hushed, anxious tones is not just a headline or a fantasy born on social media. It is the logical endpoint of a legal trajectory that has been building for years, a trajectory that could, in a single ruling, compress decades of Donald Trump's improvisational defiance into a brutal 72-hour deadline that no amount of bluster can erase. And while no such sealed order has yet appeared on the public docket, the scenario is so legally plausible and so deeply revealing about the fault lines in American democracy that it demands to be understood in full. Because if and when the nation's highest court finally tells a former president, "You have 72 hours to comply," it will not happen in a vacuum. It will be the culmination of a hidden battle that has already been fought, largely out of sight, in the quiet corridors of grand juries and sealed federal courtrooms where cameras are forbidden and the familiar spectacle of Trump's rallies and talking points gives way to something he has never controlled, the cold, methodical logic of the law. To see how we arrived here, you have to picture a chain of events that begins not with television drama but with paper subpoenas, and the one institution in America that works almost entirely behind a veil, the grand jury, whose very design prioritizes secrecy over spectacle, because when federal prosecutors believe that crucial evidence is being concealed, financial records that trace money flows through shell companies and foreign banks, internal communications that show who made decisions and why, messages that hint at contacts with foreign nationals whose names appear in intelligence files, they do not hold a press conference. They go to a grand jury and ask for a subpoena that compels production, and when the target of that subpoena is Donald Trump, a man who has turned resistance into a personal brand, the stage is set for a collision that feels, in hindsight, almost inevitable. Trump fights demands for transparency as reflexively as he breathes, insisting that every request for documents is harassment, every question about his finances is a witch hunt. Every investigation is a plot by the deep state, so when a sealed subpoena lands in his lawyer's hands, demanding, for example, all financial records since 2015 involving foreign entities, all communications with named foreign nationals whose identities are so sensitive they appear as redacted blocks in the court filings, and all documents and messages related to seeking things of value from foreign sources in connection with U.S. elections. His team does what they always do: they resist, filing motion after motion under seal, invoking executive privilege, attorney-client privilege, presidential immunity, and a dozen other legal theories designed to push the confrontation as far into the future as possible. But sealed or not, the federal system has rules and judges, and an appellate structure that does not bend simply because the defendant once occupied the Oval Office. So those motions are briefed, argued, and denied in a district court whose docket numbers mean nothing to the public because the entire matter is classified or highly sensitive. The appeals court reviews the decision, weighs the same arguments, and rejects them again, leaving Trump and his lawyers with one last card to play to petition to the Supreme Court, which they file in the hope that a conservative majority and 3 justices he himself appointed will finally give them what lower courts have refused: a shield broad enough to keep the records buried. What they may not fully appreciate, however, is that by dragging the fight to the top, they have also invited the one institution that can end it decisively into the arena. Because when the Supreme Court chooses to speak clearly on a matter of presidential exposure, it does so with a weight that no trial judge or circuit panel can match, and an order that says, in effect, "We have heard you, we have considered your arguments, and now you have 72 hours to comply with this subpoena." With no further delay is not just another loss, it is the legal equivalent of a trapdoor opening beneath a strategy that has always assumed time is infinite. Viewed from the outside, 72 hours to comply sounds like a generic countdown, another piece of YouTube melodrama, but inside the courtroom world it carries nested meanings. It signals that every avenue of appeal has been exhausted, that the justices see no legitimate unresolved question left to consider, that any further litigation is simply obstruction dressed up as advocacy, and so they slam that door shut by attaching a hard deadline that transforms vague promises into measurable action. At the end of those 3 days, either the documents appear or they don't, and if they don't, the question for lower courts is no longer, what is the scope of privilege? But is this outright defiance of a lawful order, which opens the door to contempt proceedings that can range from escalating fines to, in extremis, pre-trial detention designed not as punishment for a past act but as coercion to force compliance? Now imagine that, as often happens in high-stakes investigations with national security overtones, this subpoena is not about one narrow incident but about patterns, about whether streams of foreign money line up with political decisions, Whether private assurances to oligarchs or foreign officials contradict public claims about America first, whether back channel messages around election periods show an appetite for assistance that federal law flatly forbids, and you begin to see why the government might argue for, and courts might grant, unusual secrecy on the way up the chain, because exposing the existence and scope of the subpoena too early could compromise intelligence sources, tip off other targets, or even disrupt parallel investigations unfolding quietly in other corners of the justice system for Trump, whose entire persona is built on controlling the narrative. Such secrecy is a nightmare scenario, because he cannot preempt or spin a fight the public does not know exists, cannot summon crowds to denounce a process they cannot see, cannot fundraise off docket entries they will never read, and when the Supreme Court finally speaks, it does so not at the start of a public brawl, but at the end of a sealed war he has already lost in lower forums, a war he thought he could keep contained until some political miracle rescued him, and as news of the ruling seeps into the outside world, through careful, sourced reporting rather than campaign rhetoric, Americans are confronted with a reality that cuts through years of maybe and what if there has been, for more than a year, a classified legal struggle over Trump's records that touches on national security and foreign influence, and the last excuse has just expired. What makes this moment more than a dry procedural event is the way it collides with everything we have already seen of Trump's behavior in more public trials, the outbursts at judges when rulings go against him, the visible agitation when insiders testify, the refusal to sit calmly while evidence is described, the pattern of attacking the legitimacy of courts themselves rather than engaging with the substance of the claims, and if that pattern repeats here, if he storms onto social media to call the justices corrupt, to declare the order illegitimate, to vow noncompliance, those very statements become Exhibit A in any future contempt motion. Proof of intent that prosecutors do not have to guess at, because he has supplied it in his own words. Legal experts would dissect the ruling line by line, noting that its language carefully separates legitimate presidential acts from personal conduct, drawing a bright line between shielding core functions of the office and insulating a private citizen's business entanglements or campaign behavior from scrutiny. And even conservative analysts who have often defended him on cable news would be hard-pressed to explain away phrasing that invokes matters of significant national concern and warns that any failure to comply fully and in good faith may trigger immediate sanctions. Because at some point, even sympathetic lawyers must acknowledge that the court is not obligated to tolerate endless stonewalling for his attorneys. The 72 hours are a logistical and ethical gauntlet they must locate, review, and produce mountains of records accumulated over years of chaotic management. Fragmented storage and deliberate obfuscation, knowing that cooperating too slowly invites sanctions while cooperating too fully may expose conduct that spawns new charges, and all the while they are acutely aware that a cooperating insider, someone who once enjoyed Trump's trust and proximity, may already have given prosecutors a roadmap, complete with notes, dates, and descriptions of the very documents at issue, so that any conveniently missing pieces look less like accidents and more like destruction. Inside Trump's orbit, the countdown deepens existing cracks. Some advisors urge aggressive compliance to avoid the risk of contempt and pretrial detention that would shatter his strongman image. Others insist that confronting the court itself will electrify his base and prove that he alone is willing to face down the corrupt establishment. Still others quietly begin to distance themselves, eyeing their own legal exposure and wondering whether they will soon be asked under oath what they knew about the subpoena, when they knew it, and what role they played in any search or non-search for responsive documents. Beyond the legal chessboard, the political implications ripple outward. Trump is not a retired figure fading into history. He is an active candidate for power, and a Supreme Court order forcing him to choose between transparency and defiance lands in the middle of a campaign in which he has told supporters that all investigations are hoaxes, that every indictment is proof of his strength, that he alone can fix a system allegedly stacked against them. So when the one institution he has relied on rhetorically, my justices, my court, draws a line, his narrative fractures, and voters who have grown numb to years of scandal are confronted with a more binary question. If he complies and the records reveal deep, previously hidden ties to foreign money and influence, can they still chalk it up to fake news and move on? And if he refuses and courts begin contempt proceedings against a man who wants to return to the most powerful office in the world, can they still tell themselves this is just normal politics for Americans who care less about partisan advantage and more about the health of the republic? The 72-hour order represents something even larger, a stress test of the idea that no one, not billionaires, not celebrities, not presidents, is above the law. Green. And behind the headlines and cable chyrons lurks a quieter, more existential question. If the system cannot or will not enforce its own rulings against someone this prominent, if a Supreme Court opinion can be treated as optional by a former commander-in-chief without consequence, Green, what message does that send to every future occupant of the office who might be tempted to treat public power as a private asset? Green, that is why legal scholars compare a potential showdown of this kind to United States v. Nixon, not because the facts are identical, but because the principle is at some point. The court may have to say to a figure who has wrapped himself in the aura of the presidency, "You are a citizen, subject to the same commands as any other," and then back that declaration with teeth in the final hours of the countdown. As cameras camp outside courthouses and commentators speculate breathlessly, the reality is both simpler and more sobering than the noise suggests. Screen. The Supreme Court will not arrest Donald Trump. It will not storm his properties. Screen. It will not march him in chains before the cameras. That is not how our system is built. But it will have set in motion a binary outcome that exposes something fundamental about him and about us. Because either he complains and we begin at last to see on paper what has been argued in shadows for so long, how he moved money, how he courted or rebuffed foreign offers, how he blended private interests with public power, or he does not. Green. And we learn whether the judiciary is willing to impose real consequences on a man whose entire life has been predicated on the belief that rules are for other people. Green. That deadlines are suggestions that institutions will always blink first, and in either case, the 72 hours do not simply run out. Screen. They etch a precedent into the architecture of American law and memory, a line future generations will look back on when they ask whether, in the age of Trump, the Supreme Court merely commented from the sidelines, or finally stepped in and said, "This far and no farther."